addressed in answering Delegate Campbell's question, that this is a criminal penalty as it stands, as a misdemeanor. It's more than a fine, it's a misdemeanor. So the common instance of moving a Class 1 misdemeanor to a Class 6 felony on 3 subsequent offenses would be in line with the seriousness with which one takes these issues.
Okay, I've got Delegate Lupasi up next.
Yes, sir. I have a motion to lay it on the table.
So a substitute motion, correct?
That is correct.
Okay, so here's where we are. We've got Delegate Herring made a motion to report. Delegate Lupasi makes a motion, a substitute motion to lay on the table. The next person I identify is Delegate Adams. So Delegate Adams seconds the Lupasi motion to lay on the table. So now we have a motion to lay it on the table. All those in favor of laying on the table say aye.
Aye.
All opposed?
No.
Okay, I have no idea. Okay, can I ask for hands, please? All those who want to lay on the table, please raise your hand and ask the staff to count. This is lay on the table. Okay, do we have a count? Okay, all those against laying on the table, raise your hand. Okay, the bill is laid on the table. Mr. Chair. Okay, Delegate Bell.
Mr. Chair, we have Delegate O'Quinn's bill. He is not here. It passed 10 to 1. I could describe it.
Okay.
Mr. Chair, this bill addresses where you can apply to petition for restoration of your gun rights.
What happened on that?
It allows the petition for the restoration of such rights in the General District Court of the city or county in which the most recent of such proceedings occurred. Currently, it must be in the General District Court of the city or county in which the person resides. And the issue is, if they've already moved out of the state, they need a place to go. We have a substitute. I would move the committee substitute.
Is to adopt the committee substitute has been properly seconded.
Second.
Okay, all those in favor of adopting the substitute say aye.
Aye.
Okay, close.
Mr. Chair, the recommendation of the subcommittee was to report the substitute 10 to 1, and I so move.
Okay, move to second to adopt to report the substitute. Anybody in the audience want to speak for or against the bill? Any members of the committee have any questions? Delegate Mullen, did you have a question?
No, I
Okay.
was telling you what I...
Okay, got it. All right, so then we are going to vote on the bill. All those who want to vote this bill indicate your vote on electronic voting board. Okay, close roll. Reports 19 to 0.
Mr. Chair.
Okay, Delegate Bell.
The next bill and the last bill from the subcommittee will be 2339. It's my bill. Mr. Chair, this would... Okay, I'm sorry, there's one more, that's correct. Mr. Chair, this would allow for a court to state that a probation officer could apply intermediate sanctions. This would be a short jail sentence. It would only be allowed by agreement of the defendant. In other words, the defendant comes in, he has a violation, probation officer could say, either we can file for a PB-15 and go through the normal process, or by your agreement, you can serve up to a 5-day jail sentence. It would require him to tell the probation officer, the probationee what the problem was, give him a letter with an issue, clear it with the supervisor, and it could be for no more than an aggregate of 30 days before the person gets brought back to court. The goal, of course, is to try to make at least the smaller sanctions apply more quickly where the probationer agrees that he did it and is comfortable doing it. That's the bill. It's being done in two other states, North Carolina and Kansas. And I would recommend we report. The committee recommended 7 to 4. I so move.
Okay, what was the vote?
7 to 4, and I so move.
Okay, so there's a motion to report. Delegate Morris.
Yeah, a question for the patrons. My understanding that their probationary officers already have certain parameters where they can implement immediate sanctions, just not jail time. Is that correct?
Okay. they, the only, when I say intermediate sanction, what I mean is jail, so, but I'll answer the question I think you're asking, which would be, yes, they certainly can impose other things, like you have to show up more frequently, be in a cup more frequently, that kind of thing. The one that everybody cares about, if you're probationer, of course, is when you go back to jail. Currently, there's no provision except to file the paperwork has been served, the person has been arrested, he's brought to the jail, he's asked if he wants a lawyer or not, he then gets a lawyer appointed, they then set it on the docket then comes on an available day, and weeks later he's brought before the judge for a penalty. And this would say that if the defendant is agreeable, and only then, he can short circuit all that and say, I'd like to go in for a 2-day, 3-day, 5-day hitch. It's a maximum of 5 days, and then he would be released.
And I guess the other question would be, is there
Elliot
other...
Morris, and hold it, guys. Okay, so I've been doing this 24 years, and I've been chairman of this committee for 10, and this always happens. Because we get to really late, and this stuff's serious stuff, and we're all tired, okay? But we need to just kind of, if you're going to talk, just whisper or go to the sides, because we're not hearing what people are saying, okay? So Delegate Morris.
Mr. Chairman, are there less severe sanctions that the probationary officer could offer, such as community service or something other than having to pee more frequently, that is an option for the probationary officer?
What you come down to is ultimately it all is the penalty that makes all of that work is jail. So he can do everything he wants, where he says, if you don't do this, we'll go back to the judge. If you don't do this, we'll go back to the judge. He can do anything except for jail on that basis. He could do more community service, more visits. Got to check in once a day instead of once a week. You got to keep that job, stay away from that person. Those are things he can make the person do. If the person doesn't, if he breaks the rules, that's when you have the question of what do you do? And they've had good results, they're preliminary results, but good results in Kansas and North Carolina, where they say, we're not going to wait all this time for the punishment when you come in. It's usually a dirty screen. And it's usually just you're already doing community service, you're already making the visits, you're already getting the drug counseling. We told you to stay off the drugs, you come in, you're dirty. And the question is, you're already doing all those things, what do you do now? And this is just one more option for them rather than the more long drawn out report.
Mr. Chairman, can I have just one final question? So I understand that you're trying to, the intent is getting up to that point where they have tried all other measures, but I don't see that written into the bill. My concern is when the probationary officer does not try all those other measures, but immediately jumps to, you either take this 5 days or else, instead of the less severe options. And it's that discretion that bothers me.
I would say to the gentleman, any defendant, probationer, I guess, at that point, who thinks this is unfair, that it's happening too quick, and wants to go through the normal process, he just says no, and we're back on the regular track. The thought would be, in some enormous percentage of probation violations, and I don't want to guess, 99%, some huge number, the argument is never about whether he did it. It's not about whether it's dirty or not, or whether he arrived late, or he quit the job, or saw the person he wasn't supposed to see. It's just a question of getting him in front of somebody to give him the punishment, how bad the punishment should be. Usually by the time they've waited in jail to get to the judge, they've already served this much time. The thought would be, rather than arrest you and then hold you and then get you a lawyer, by the time you're there, you've served 14 days for the judge to let you out on time served. We could do it more quickly this way, but only if the probationer thinks it's something he's willing to do. Thank you.
Okay, we made a mistake and did not adopt the amendments yet, and so, okay, move to adopt the amendments, there's a second.
Second.
Move to second, adopt the amendments. All those in favor of the amendment say aye.
Aye.
All opposed. Okay, amendments are adopted. Where we stand procedurally right now is there is a motion to report. Mr. Bell is going to amend his motion to report to be motion to report as amended.
I do.
Okay, and Delegate Gilbert, Klein, then Adams. Gilbert.
Mr. Chair, in following up on Delegate Morris's question about lesser punishments that a probation officer can impose, I would ask the subcommittee chair, what would patron of the bill, can't probation officers currently, and wouldn't they still be able to do things like ignore violations so as to, say, artificially reduce recidivism rates?
I say to yes, this is not, we've had other proposals that have said every single violation you have to bring. This doesn't do that. This just says, at some point in the process, if you wish to make this one of your penalties, you certainly do.
Okay, Delegate Klein.
Okay, I'm not aware of anywhere else where we have this collaborative decision-making process about whether somebody goes to jail or not. And it is a very big shift that will be expanded rapidly to various other things if we start allowing someone other than a judge to put someone in jail. I don't even know. I mean, I would say this, if you think that somehow the defendant or the convicted individual who is on probation is on a level playing field with the probation officer when they're negotiating about whether they're going to agree to that, you're crazy. There is major leverage here that this probation officer is putting on this individual to agree to go back to jail. And if not, they're going to file a show cause. If not, they're going to send them up the river for even longer. If not, they're going to make them do community service. So you've got this pressure situation where the individual is not agreeing, is not really free to agree or free to disagree. And I just don't think it's a fair way to do things. So I'm going to go against it.
Okay, Delegate Adams.
Speaking to the bill, Mr. Chairman.
Yes, sir.
Just
Proceed.
point out, I believe the position of the Office of the Executive Secretary for the Supreme Court was opposed to the bill, and I think some of the ideas expressed there have to do with when you think about the judicial requirement that we put on our judges for qualification, for independence. All of those things are factors that come into play for some of the points raised by Delegate Klein. We have probation officers who are simply not qualified, not trained to be put in that type of situation and exercise that type of independence, in my view. And so I would ask that we vote against it as well.
Okay. First, we need a second to report. Is there a second? Moved and seconded to report. Anybody in the audience want to speak for or against the bill?
Eileen Smith with OES at the Supreme Court, Mr. Chairman. As Delegate Adams indicated, circuit court judges oppose this bill because it's delegating to probation officers the authority to adjudicate someone guilty of a violation and impose jail time.
Okay. Anybody else?
Lori DiGiustino with the Virginia Association of Commonwealth Attorneys, and we support this measure. There are 5, and I can name Arlington, Lynchburg, and Henrico that have pilot programs that do this. All of those jurisdictions gave feedback that this was a very positive approach to have that immediate sanction. Is it a different one?
Mr. Chair, while I would love to have the support she's offering, it is not accurate. That this is
Immediate sanctions are still done by the judge, right?
Right. This is different. This is not
Oh,
the
this is,
judge.
okay, I apologize. Those jurisdictions, though, did say that something like this, where you would have an immediate sanction, what they liked about it was that it was related directly to the conduct. It was something that can be done rather than down the road. You have the sanction, which has less effect and connection to the behavior. Additionally, we thought it would be positive because it would not be dragged out through the courts where you have to have it filed, you have to have the court system, and then the hearing related to that behavior months prior would come up months later. So we do support the measure.
All right, thank you. Anybody else? All right, the motion then has been properly made and seconded. All those who want to vote this bill indicate your vote in the electronic voting board. Okay. Close the roll. Ms. Bailey's report.
Mr. Chair, I would consider the vote whereby I had this clever idea at midnight when I worked your bill. All right, Mr. Chair, the last one is Delegate Ferris's bill. That was your bill that you did all the work on and nobody else liked. So,
Well, enough liked it, it got out of committee.
you had a lot of in concept.
Right.
All right, Mr. Chair, that's the last bill that we have.
Okay, I'm going to go ahead and try to explain this, but Delegate Ferris left, so I'm not quite sure how much time we want to spend on it. But. Okay, so there is there a motion on the substitute? Someone move the substitute, please. Move the substitute second. All those in favor say aye. Aye. All opposed? Okay, the substitute's adopted. Okay, as we're handing out, let me tell you what topic we're working on. We're working on a topic of unmanned aerial vehicles or devices. And there are 2 issues. One issue we dealt with in the uncontested block, and that's when you take a drone and the person uses it to peep into somebody's house. And the problem is the peeping statute requires the person to do it individually. What we decided in another bill is to say that if a person uses a drone to do, it should still be illegal. That one passed uncontested. The second issue is where someone is flying a drone around somebody's yard, purposely bugging the heck out of them. Delegate Ferris has a constituent, and his daughter was sunbathing outside. And I think she didn't want to have scrap marks for her prom, so she was sunbathing without her top on, and the next door neighbor kept flying a drone over and taking pictures of her. And the father went to the next door neighbor and said, "Would you please stop flying your drone over my yard?" And the guy never stopped. And the police and the prosecutor said, under current law, we can't stop anybody from flying a drone over your yard. So this attempts to make it illegal to fly a drone over somebody's yard and annoy them at the same time. Here are some issues that we had that we discussed in the committee. Number one, Northern Virginia Technology Council does not like signaling out certain technologies for different treatment. So whatever you see here that says electronic device, it used to say unmanned aerial vehicle, but now it says electronic device. So, line 11, any person, after having been given notice to desist, knowingly and intentionally causes any electronic device to enter the area of a dwelling house of another, or the curtilage of such dwelling house, with the intent to coerce, intimidate, or harass another person guilty of Class 3 misdemeanor. If you do it again, it's a Class 2. Now, Section B is attempt to carve out business activity where people may be flying over your yard, not with the intent to harass, but they're just trying to do their job. The best example of that would be a Dominion. Dominion would have these unmanned aerial vehicles to go check the big high wire, high tower, heavy wire things. And instead of sending a person up, which is very dangerous and expensive, they just want to fly the drone to look at, make sure their towers are okay. They have to fly over your yard and they have to take a picture, just get from point A to point Z, because the camera is what they use to navigate. Can I ask you guys, do you have any connection with taking out subparagraph 1 in this?
Mr. Chairman, Patrick Cushing with the Unmanned Systems Association of Virginia. I think that we would be okay with that as kind of a continued effort to work on this bill, if that's the will of the committee.
Delegate Bell, in conversations with me, has a problem with this phrase on line 17, primary purpose, because we don't really use it in the code. So I'm going to move to strike on line 17 the one little I and the two little I, so that the bill would say, this section does not apply to any person who uses an electronic device to enter the area or curtilage of a dwelling house if the entry is reasonably related to any lawful business purpose or activity. Okay? Moving second to do that. All those in favor of striking that say aye. Aye. All opposed. Okay, so now here's what we're talking about. We're talking about this bill as amended with that little I out. And now we'll have anybody in the committee have any questions? Okay. So any members of the audience want to speak for or against the bill? Patrick, yes, sir. Go ahead.
Mr. Chairman, there's one more issue I want to bring up.
Okay,
It's relatively minor. If the patron was here, I would have pulled him aside to ask this, but I'll just pretend as if he's standing right here and ask him, that was the intent of this as a trespass statute to prohibit the entry upon the property of another? The reason I ask is because on line 12, you have electronic device to enter the area of a dwelling house. In situations where you have zero lot lines or very tight neighborhoods or properties, you may have a dwelling house or the curtilage thereof that is in the area of somebody else's property where you are flying legally on your own property. So a potential suggested amendment would be, after electronic device to enter on line 12, you would insert the property of another and subsequently the area of a dwelling house, right, of another, or the curtilage of such dwelling house. So I think you need the prerequisite that you cross into the property of another, and then you are in the area of the dwelling
In
house.
other words, you don't want to be busted on this, if you're flying it on your own property, it also happens to be the definition of the other thing. Does that make sense to you, Steve?
Mr. Chairman, it does make sense, but in the instances that he describes where these houses are close together, that the hard part of prosecuting the statute is always going to be, where is that property line in the air? And if my house is 10 feet from the other house, if a gust of wind blows my drone 6 inches into the other property, have I then violated the statute? And I could annoy, or we took the word annoy, I could harass my neighbor by staying 6 inches into my property line if I'm flying it right next to the property. So it fits in those rural areas, but it's sort of very going to be hard to do.
So Delegate Bell just thought it might be better just to say, instead of dwelling house or curtilage, property of another person. Then you got farms, 50 acres and stuff. Okay, so Delegate Bell says property, Delegate Klein seconds it. Electronic device to enter, and you strike the area of a dwelling house of another or curtilage of such dwelling house, and insert to enter the property of another. Everybody understand the amendment?
Speak up.
Okay, so all those who want to vote on this bill indicate vote by saying yes. Not the bill, but the amendment. Yes. All opposed? Okay, the chair believes that there was a majority of people who wanted to adopt that amendment.
Mr. Chair. Mr. Chair.
Delegate Bell.
Question for council. We say knowingly and intentionally. Don't we want to say purposefully? And I say that because if I am a legitimate use of the drone, and I know that it harasses someone, it is not my purpose to harass them. I'm just wondering, intent as being the likely and probable consequences of your action. If our goal really is to allow for.
I've never heard of purposefully in the code.
Okay. Never mind.
Mr. Chairman, I think when you put it, what I was discussing earlier with lobbyists, is that when you have the intent to coerce, intimidate, and harass, it is now a specific intent crime, so that would have to be your purpose, as opposed to in a general intent crime where then what Delegate Bell mentions, you intend the probable cause of your actions. This becomes a specific intent crime, and says intent to coerce, intimidate, and harass.
Okay, I know. Anybody want to speak for or against the bill? Go ahead.
Mr. Chairman, comments on the amendment.
Policy.
Let me speak to the amendment that was just adopted, because as this was presented, I think my association was good and off to the Senate. However, with that amendment, we have now broadened this to include all property, not just the dwelling area and the curtilage, and so we've got a problem with that. We'd be opposed to that amendment.
Okay.
Mr.
What
Chairman,
it's worth.
Delegate Habib.
parliamentary inquiry.
Yes, sir.
This was a civil bill written 8.01 when it was filed with no criminal element. We have now laid a criminal bill on top of an 8.01 civil bill and created a new crime. Is that germane?
What was the original bill? Was the purpose?
The original bill was 8.01 40.4, invasion of privacy, civil action.
Hey, criminal complaint,
I don't see
dealt
it.
with trespass?
It said if you do this to engage in criminal activity, then it's a cause of action.
Well, I know we've taken criminal bills and made them civil penalties before.
And we have had bills that had both, and we dropped part out. I've just never seen an 8.01 bill become an 18.2 bill or vice versa. Yeah, Kilgore's bill had the other stuff in it. This is just a pure civil bill.
Kilgore's bill was what? Oh, so his bill didn't?
I mean, you could lay this on Kilgore's bill, I think, but I don't think you can lay it on this bill.
Is there anyone else?
No. Can I see a copy of the original bill? Okay, I'm gonna rule, I hereby rule that the original title was Invasion of Privacy, and this accomplishes the same purpose, but does it with criminal penalties instead of civil penalties. So I'm gonna say it's germane, but that was a very interesting little topic. It may not. Okay, yes, and then, anything else? Patrick? No, not at this time. Okay. You guys next?
David Skiles with the Vector Corporation on behalf of DJI. I would echo Mr. Cushing's comments regarding the change to the property.
Okay, so here's where we are. Under the prior version that was dwelling house and curtilage, there was not really that much of an objection from anybody. Now that it says entire property, there is. Okay? Any members of the committee? Delegate Bell.
I'm no longer sure that the will of the subcommittee was to report, since we made so many changes, that it was in fact the vote, so I will move. It was in fact the vote of the subcommittee to report whatever it was we had, and I so move.
All right. Any seconds? Okay. Greg, did I already acknowledge you and just not?
Yes, that was my motion. I never turned it off. Thank you.
Okay. All right, and the motion is to report as the substitute as amended. All those who want to vote in this bill indicate your vote electronic voting board. Okay. All right. That's it. Close the roll. Okay. 17 to 2. It reports. Now, we only have the one pending thing, which is the texting and driving, right? Okay. So right now, we've reconsidered it. Is there any motion? Are there any motions on that bill? It's in the rest of the committee. Are there any motions on?
Move to report.
Moved to report and seconded. Delegate Campbell. Okay. Delegate Miller, Delegate Habib.
Speaking of the bill,
Go ahead.
Mr. Chairman, one, this is, I mean, procedurally, I think this is a bad day for this committee and what's going on in here. And I think it's gonna have longer term repercussions because of the sort of loss of confidence in the procedures here. But substantively, again, we are making Uber illegal potentially. We are making Lyft illegal potentially. We're having this whole conversation about PTNCs that we may be now making illegal in Virginia. We've already talked about GPS. We've already talked about music. I totally get what Delegate Anderson is trying to do. And this bill does not do what he is trying to do. Instead, it entirely shuts down the modern economy. It shuts down the way we communicate. It shuts down the way we travel. And you can act like it doesn't, but it just does. And we had the Commonwealth's attorneys up there who said, yeah, you're right, it covers GPS. Yeah, you're right, it covers music. Well, yeah, you're right, it covers Uber. It's just bad policy is written. And sometimes we hit the end of crossover or session and we just couldn't get the words right. And that's what happened here, and this bill should not go forward.
Okay, now Delegate Miller's button's not working. I'm going to recognize him in a second, but I'll recognize myself. As far as this being a bad procedural policy, moments before we did this one, we reconsidered Kilgore's bill, and no one had a problem with it. The only reason some people have a problem reconsidering this is because they don't like the bill. I had no idea that Toscano decided that he had to go someplace, okay? So this is not done for trickery. I actually asked to see if we could get it come back up early, because I did not want to do what used to happen in the old days, where they put it on the end of the docket when half the people aren't there in secret after the people left. So this was done just like Kilgore's, as fast as I could possibly do it, okay? Right, now, Delegate Miller.
Mr. Chairman, can I have a few questions of the council?
Sure you can.
So, in all fairness, I was never very supportive of the but it wasn't adamantly opposed until I heard Delegate Campbell make some comments earlier. And I want to ask council this. So the way we're written right now with this bill, I'm driving down the road. I'll give you a scenario. I have this plugged in, and I have it sitting on my passenger seat, like I always do. And I notice it when it lights up because it goes dark. And so I reach down and I get a drink and I swerve a little. Police officer pulls me over. And as he's walking up, he sees this start lighting up because my wife is texting me. And he asked me, "Sir, were you texting while you were driving?" And I say, "No." Well, you said you swerved. I'm like, "Oh, I reached down and got a drink." He says, "Were you paying attention?" I was like, "Oh yeah, I do. My wife texts me and I do look at it when she's texting me and I'm driving." Under this law, if I have it, I mean, I was a policeman for a while and I can see me and I can see my colleagues doing this. I get a little bit irritated with the officer and I maybe say some things I shouldn't to him. But I do tell him, yes, I used the phone. I was looking at it as my wife texted me. You could see it lighting up. My wife was texting me. And he says, well, that's a crime. And that's my evidence. Could he take that phone as evidence of that crime away from me there at the scene?
Mr. Chairman, Delegate Miller, he could seize the phone. He would obviously need a search warrant to search it, but he could seize the phone and hold on to it until you went to trial. And there's really no recourse other than you could look for a writ of some sort.
So under that scenario, my entire life is in this thing, and I probably won't get convicted because hopefully the judge would say no. I'd say, "No, Your Honor, I was drinking. I barely moved within my lane. Officer saw me and pulled me over." But for a month and a half, I no longer have access to this phone that basically my entire life is. All my clients, all my colleagues, everything else, I don't have access to it until after my trial.
Mr. Chairman, Delegate Miller, theoretically, yes, there's several crimes where, and I see it in practice with drug cases and prostitution cases where they take phones all the time. The statute dealing with search warrants doesn't delineate it has to be a certain type of crime. It just says evidence of a crime.
Thank you. Okay, any questions, anybody else? Okay, so motion is, I forgot, we have a pending motion to report. Yeah, we have a pending motion to report. Does anybody else want to speak for or against the bill in the committee? Okay, then we're going to go ahead and vote. All those who want to vote on this bill indicate your vote in the electronic voting board. Okay, is that everybody voted? All right, close the roll. It fails to report 9 to 10. Okay, now before we get up, let's make sure we didn't make any mistakes. All right, we are ready to adjourn. Okay,
Mr. Chairman.
Yes, well, before I get bang the gavel, does someone say anyone?
I would call a motion.
Delegate Campbell, sorry about that. Yes, sir.
Mr. Chairman, having voted on the prevailing side whereby we failed to report House Bill 2335, I move that we reconsider.
Okay, can you tell me what 2335 is?
That's Delegate Watt's bill regarding
Okay, so
contract.
everybody, is there a second to reconsider?
Second.
Okay, well, it has to be by a person who voted on the prevailing side.
Never mind.
Is there someone who did not like that bill? So Scott would know. Do you need a second for a motion to reconsider?
Can we do everything? I move that we do everything.
Oh, it's a privileged
twice.
motion. Wow. Okay, so all those who want to reconsider Vivian's bill say aye. Aye. All opposed? No. Okay, all the ayes, raise your hand. To reconsider. Okay, all those who don't want to reconsider.
I know, there's two hands. Oh, you're so tough.
What was the vote now? 9 to 8. 9 to reconsider, 8 to not reconsider. Okay, so it's now being reconsidered. Delegate Watts.
I believe
Delegate Campbell.
Mr. Chairman, in speaking with Delegate Watts, I think she is inclined to insert some amendments to her bill.
To speed it up, as I understood our conversation, I am totally in agreement that within a 36-month period is a very appropriate amendment because it deals with the predatory behavior, and I have been told, but I haven't had a chance to look for my own eyes, that in fact this is used elsewhere in 54.1. So with
What you want
that,
to do is you want to amend the bill to make it look like other offenses in 54.1 that say that the 3 offenses have to occur within 36 months? Okay, is there a second to that? Moved and seconded to amend the bill. All those in favor of that amendment say aye. Aye. All opposed. Okay, so now we are here with the bill with the proviso that the 3 offenses have to be within 36 months. Is there anybody else who want to speak for or against the bill? Is there a motion on the bill? Oh, Lupasi.
No, I got my speak button. I want to speak to the bill.
I have not recognized any motions yet, so go ahead.
I have a motion to lay it on the table, and I'll speak to the motion.
You can't. If you make a motion to lay on the table, you can't talk. If you make a motion to PBI, you can't talk.
All right, I'll make a motion to lay it on the table.
Okay, motion is laid on the table. Is there a second? Second. Okay, now, Delegate Herring.
Well, never mind, I was,
That's right, okay. All right, so the motion now is to table. All those who want to table, say aye.
Aye.
All opposed? No. Okay, in the ears of Albo, I hear knows when. Okay. Right. All right, anybody else want to make any other motions?
Move to report.
All right, Delegate Melanie, support, Bill, seconds. Delegate Lupasi,
Okay, I'd like to speak to the motion.
speak to the motion.
Okay, this does not fix the issue. And the issue is you're making it a felony for someone who, that's in,
Lupasi, go ahead.
it's public policy. You're taking someone's gun rights away because they're fixing 3 bathrooms in 3 different locations without a license. Okay, that's what you're doing. That's what you want to do, fine, but that's what you're doing. You're making them a felon. So, I think it's wrong. I don't think it's necessary. Right now, you can give them up to 12 months in jail for 1 violation. If the judges are not giving them 12 months in jail for this horrid crime, then maybe we need to appoint stronger, harsher judges.
Yes.
Okay, anybody else? All right. All those who want to vote on this bill indicate your vote in electronic voting board. Okay. Right, close the roll. Reports 11 to 8. All right, anything else?
thank you.
Take it away, okay, we're.
Thank you very much.
Vivian, that was fun. Building.